process. The bringing, maintaining, and defense of a lawsuit are generally referred to as litigation process or litigation. The pretrial litigation process can be divided into the following major phases: pleadings, discovery, dismissal, and pretrial judgments, and settlement conference. Each of these phases is discussed as follows. The pleadings, the paperwork that is filed with the court to initiate and respond to a lawsuit, is referred to as the pleadings. The major pleadings are the complaint, the answer, the cross complaint, and the reply. Now, when I form pleadings, I also form a statement of fact in support of those pleadings, or the statement of fact, and testimony in the form of an affidavit signed under the pains and penalties of perjury under jurat to support the pleadings, the statement of facts. Okay? The pleading paperwork that is filed with the court to initiate and respond to a lawsuit is referred to as the pleadings. The major pleadings are the complaint. Remember, corporations file complaints. Men make claims. The answer, the cross complaint, and the reply. Complaint and summons. To initiate a lawsuit, the party who is suing, the plaintiff must file a complaint with the proper court. The complaint must name the parties to the lawsuit, allege the ultimate facts and law violated, and contain a prayer for relief, for remedy to be awarded by the court. The complaint can be as long as necessary, depending on the case's complexity. A sample complaint appears in Exhibit 2.5. Once a complaint has been filed with the court issues a summons. A summons is a court order directing the defendant to appear in the court and answer the complaint. The complaint and summons are served on the defendant by a sheriff, other government officials, or a private process server. It's important that once your summons has been served and proper process of service has been executed, to ensure that you get a certificate of service and to file it with the clerk of the court on into the case file jacket, so later it can be used as an exhibit to prove due process of law was formally exhibited and executed, all right, properly. So you need to, it's not well enough just to file your claim. You also need to document everything to show that you have provided their Fifth Amendment due process, which is due to them. Answer. The defendant must file an answer to the plaintiff's complaint. The defendant's answer is filed with the court and served on the plaintiff. In the answer, the defendant admits or denies the allegations contained in the plaintiff's complaint. Now, generally, there are three ways that you can answer a claim or a complaint: admit, deny, and without knowledge. A judgment will be entered against a defendant who admits all of the allegations in the complaint. The case will proceed if the defendant denies all or some of the allegations. If the defendant does not answer the complaint, a default judgment is entered against him. A default judgment establishes the defendant's liability. The plaintiff then has only to prove damages. So another way that you can establish all the facts before you go into getting a summary judgment would be to get a declaratory judgment in the small claims court through your private administrative process establishing the facts. Another nice touch is when you're bringing a claim to let them know that that their failure to respond is silenced by acquiescence, and as such, your intent is to bring suit nihil decet, which means he says nothing, therefore he agrees. So to form your complaint, it may look something like this. In the United States District Court for the District of Indiana, John Doe plaintiff versus Jane Doe defendant. The plaintiff it may say the plaintiff by and through his attorney, or if you don't have an attorney, which I would strongly advise you never to get a fucking lying, looting, pandering piece of shit, it would say something like John Doe, hereinafter the plaintiff. All right. Number one, the plaintiff is a resident of the state of Ohio. The defendant is a resident of the state of Washington, and there is a diversity of citizenship between the parties. Number two, the amount in controversy exceeds the sum of $75,000 inclusive of interest and cost. Number three, on January 10, 1997, plaintiff was exercising reasonable care while walking across the intersection of Sun Valley Road and Main Street, Indiana, when defendant negligently drove his car through a red light at the intersection and struck plaintiff. Number four, as a result of the defendant's negligence, plaintiff has incurred medical expenses of $54,000 and suffered severe physical injury and mental distress. Wherefore, plaintiff claims judgment in the amount of $1 million, interest at the maximum legal rate, and cost of this action. By, and then you would sign your name. Of course, at the bottom of it, you would want your name, address, phone number, fax number, email address as well. That just helps with communication. In addition to answering the complaint, a defendant answer can assert affirmative defenses. For example, if a complaint alleges that the plaintiff was personally injured by the defendant's answer could state that he acted in self-defense. Another affirmative defense would be an assertion that the plaintiff's lawsuit is barred because the statutes of limitation, time within which to bring the lawsuit, has expired. Cross-complaint and reply. A defendant who believes that he or she has been injured by the plaintiff can file a cross-complaint against the plaintiff in addition to an answer. In the cross-complaint, the defendant, now the cross-complainant, sues the plaintiff, now the cross-defendant, for damages or some other remedy. The original plaintiff must file a reply answer to the cross-complaint. The reply, which can include affirmative defenses, must be filed with the court and served on the original defendant. Intervention and consolidation. If other persons have an interest in the lawsuit, they may intervene and become parties to the lawsuit. For instance, a bank that has made a secured loan on a piece of real estate can intervene in a lawsuit between parties who are litigating ownership of the property. If several plaintiffs have filed separate lawsuits stemming from the same situation against the same defendant, the court can consolidate the cases into one case if it would not cause undue prejudice to the parties. Suppose, for example, that the commercial airplane crashes, killing and injuring many people. The court could consolidate all of the lawsuits against the defendant airplane company. Discovery. The legal process provides for a detailed pretrial procedure called discovery. During discovery, both parties engage in various activities to discover facts of the case from the other party and witness prior to trial. Discovery serves several functions, including preventing surprises, allowing parties to thoroughly prepare for trial, preserving evidence, saving court time, and promoting the settlement of the case. The major forms of discovery are as follows. Deposition. A deposition is the oral testimony given by a party or a witness prior to trial. The person giving the deposition is called the deponent. The parties to the lawsuit must give their depositions if called upon by the other party to do so. The depositions of a witness can be given voluntarily or pursuant to a subpoena, court order. The deponent can be required to bring documents to the deposition. Most depositions are taken at the office of one of the attorneys. The deponent is placed under oath and then asked oral questions by one or both of the attorneys. The questions and answers are recorded in written form by a court reporter. Deposition can also be videotaped. The deponent is given an opportunity to correct his or her answers prior to signing the deposition. Depositions are used to preserve evidence. If the deponent is deceased, ill, or is not otherwise available at trial, an impeached and impeach testimony given by witnesses at trial. The other nice thing about deposition is, remember, affidavits allow for lying by omission. Okay? Affidavits allow for lying by omission. So an unrebutted affidavit doesn't necessarily stand true in fact in law, because an affidavit is nothing more than hearsay until you have been deposed. That's why I strongly stress doing testimony in the form of an affidavit. Okay? Under jurat. Interrogatories. Interrogatories are written questions submitted by one party to a lawsuit to another party. The questions can be very detailed. In addition, it might be necessary to attach certain documents to the answers. A party is required to answer the interrogatories in writing within a specified time period, ergo 60 to 90 days. An attorney usually helps with the preparation of the answers. The answers are signed under oath. Production of documents. Often, particularly in complex business cases, a substantial portion of the lawsuit may be based on information contained in documents, ergo memoranda, correspondence, company records, and such. One party to a lawsuit may request that the other party produce all documents that are relevant to the case prior to trial. This is called a production of documents. If the documents sought are too voluminous to be moved, are in permanent storage, or would disrupt the ongoing business of the party who is to produce them, the requesting party may be required to examine the documents at the other party's premise. Number 4, physical and mental examinations. In cases that concern the physical or mental condition of the party, a court can order the party to submit to certain physical or mental examinations to determine the extent of the alleged injuries. This would occur, for example, where the plaintiff has been injured in an accident and is seeking damages for physical injury and mental distress. Dismissals and pretrial judgments. There are several pretrial motions that parties to a lawsuit can make to try to dispose of all or part of a lawsuit prior to trial. The two major pretrial motions are motion for judgment on the pleading. A motion for judgment on the pleading can be made by either party once the pleadings are complete. This motion alleges that if all of the facts presented in the pleadings are true, the party making the motion would win the lawsuit when the proper law is applied to these facts. In deciding this motion, the judge cannot consider any facts outside the pleadings. Number 2, motion for summary judgment. The trier of the fact, i.e. the jury, or if there is no jury, then the judge, trial by bench, determines factual issues. A motion for summary judgment asserts that there are no factual disputes to be decided by the jury and that the judge should apply the relevant law to the undisputed facts to decide the case. Motions for summary judgment, which can be made by either party, are supported by evidence outside the pleadings. Affidavits from the parties and witnesses, documents, ergo a written contract between the parties, depositions, and such are common forms of evidence. If after examining the evidence the court finds no factual dispute, it can decide the issue or issues raised in the summary judgment motion. This may dispense with the entire case or with part of the case. If the judge finds that a factual dispute exists, the motion will be denied and the case will go to trial. Settlement conference. Federal court rules and most state court rules permit the court to direct the attorneys or parties to appear before the court for a pretrial hearing, a settlement conference. One of the major purposes of such hearings is to facilitate the settlement of the case. Pretrial conferences are often held informally in the judge's chambers. If no settlement is reached, the pretrial hearing is used to identify the major trial issue and other relevant factors. More than 90% of all cases are settled before they go to court, before they go to trial. The trial. Pursuant to the Seventh Amendment to the United States Constitution, a party to an action at law is guaranteed the right to a jury trial in cases in federal court. Most state constitutions contain a similar guarantee for state court actions. If either party requests a jury, the trial will be by jury. If both parties waive the right to a jury, the trial will be without a jury. The judge sits as their trier of fact in non-jury trials. At the time of the trial, the parties usually submit trial briefs to the judge that contain legal support for their side of the case. Trials are usually divided into the following phases. Jury selection. The pool of the potential jurors is usually selected from voter or automobile registration lists. Individuals are selected to hear specific cases through the process called voir dire, to speak the truth. Lawyers for each party and the judge can ask prospective jurors questions to determine if they would be biased in their decision. Biased jurors can be prevented from sitting on a particular case. Once the appropriate number of jurors is selected, usually 6 to 12, they are empaneled to hear the case and sworn in. The trial is ready to begin. A jury can be sequestered, i.e., separated from family, etc. In important cases, jurors are paid minimum fees for their services. Opening statements. Each party's attorney is allowed to make an opening statement to the jury. In the opening statement, the attorney usually summarizes the main factual and legal issues of the case and describes why he believes his client's position is valid. The information given in this statement is not considered as evidence. Number 3, the plaintiff's case. The plaintiff bears the burden of proof, the onus of probandi, to persuade the trier of the fact of the merits of his case. This is called the plaintiff's case. The plaintiff's attorney will call witnesses to give testimony. After a witness has been sworn in, the plaintiff's attorney examines, i.e., questions the witnesses. This is called direct examination. Documents and other evidence can be introduced through each witness. After the plaintiff's attorney has completed his questions, the defendant's attorney can question the witness. This is called cross-examination. The defendant's attorneys can ask questions only about the subject that were brought up during the direct examination. After the defendant's attorney completes his questions, the plaintiff's attorney can ask questions of the witness. This is called redirect examination. The defendant's attorneys can then again ask questions of the witness. This is called cross-examination. Now, if you happen to be the defendant, I would strongly urge you and implore you to find out the witness list on behalf of the plaintiff, i.e. the state, right? And you're going to subpoena every last one of their alleged witnesses, and you're going to turn them into your witnesses. And now you can ask questions outside the scope of the plaintiff's attorney, okay? It's very important that you subpoena yourself as well, in case you're accosted against your will heading to the court. Then they would be in contempt of court for holding you up and not getting you there. So always subpoena yourself and always subpoena the opposing party's witnesses. Period. End of story. Don't ever get a hold of me saying that you didn't subpoena yourself to the case and you didn't subpoena the witnesses of the opposing party. I don't ever want to hear anybody calling me saying that they have failed to do that. It is so fucking important. And I learned that the hard way. So I'm speaking with firsthand perfected knowledge about those facts. The defendant's case. The defendant's case proceeds after the plaintiff has concluded his case. The defendant's case must 1. Rebut the plaintiff's evidence, 2. Prove any affirmative defenses asserted by the defendant, and 3. Prove any allegations contained in the defendant's cross-complaint. The defendant's witnesses are examined in much the same way as the plaintiff's attorney's cross-examination cross-examines each witness. This is followed by redirect and recross examination. Again, if you're bringing a counterclaim or a cross claim, and you were the defendant, obviously, in that situation, you get to go first in court. So remember that. If you've got a cross claim or a counterclaim before the court and they start out with the plaintiff, you gotta call an objection. You gotta call an audible foul. Throw a flag on the play, because you get to go first with your cross complaint or your counterclaim. All right, as a defendant. Number 5, rebuttal and rejoinder. After the defendant's attorney has completed calling witnesses, the plaintiff's attorney can call witnesses and put forth evidence to rebut the defendant's case. This is called a rebuttal. The defendant's attorneys can call additional witnesses and introduce other evidence to counter the rebuttal. This is called the rejoinder. Closing arguments. At the conclusion of the evidence, each party's attorney is allowed to make a closing argument to the jury. Each attorney tries to convince the jury to render a verdict for his client by pointing out the strengths in the client's case and the weaknesses in the other side's case. Information given by the attorneys in their closing statements is not evidence. It's all, for lack of better words, it's theater. It's all theater. Romeo, Romeo, where art thou, our Romeo? It's all theater at that point. And in my first trial, boy, the fucking theater was good. It was good. Closing arguments. Covered that. 7, jury instructions. Once the closing arguments are completed, the judge reads jury instructions or charges to the jury. Okay, this is where I first learned how to create a legally binding contract. I watched a judge instruct the jury, hand everybody the instructions, made sure the defendant had their set of instructions, made sure the plaintiff's attorney had their set of instructions, and we all read it together. And we were all asked, do we understand? We all agreed to the terms and conditions in the jury instructions. But what I found amazing is you can create your own damn jury instructions, especially if you're the only real party in interest. What I mean by that is if it's the state of Nebraska persecuting you, you're the only real party in interest, and you can create the fucking jury instructions that says the jury not only decides the facts, but they also decide what the fuck the law is. You should take heed in what I just told you. That's very, 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 very fucking important, because we, the people, decide what is law in this country, contrary to everybody else's fucking belief. We, the people, are the first line of defense. Our battle to correct bad behavior or unbecoming behavior of public officials and government and alleged laws is not had by petitioning the legislator for remonstrances and shit like that. It's right there. The jury of 12. We get to decide whether it's horse shit or whether it's reasonable and naturally applies to everybody because it follows natural law, God's law. There's a victim, there's a crime, and for that victim and that crime, there's retribution that needs to be had, or restitution that needs to be had, and there's some type of sentence that needs to be handed down because logistically, morally, and ethically, it makes sense, right? And in the event that there is no victim, there is no fucking crime, they're charging you with something criminal, we want a jury of 12 to go, you know what, that's bullshit, and that doesn't apply to we the American people. All right, that's null and void. Okay, so we the jury, we the members of the jury get to overturn bad perceived law. And a lot of the stuff they call law are ordinances, city codes, shit of that nature. It's not law, okay? It's only law if you agree to it. If you don't agree to it, the people don't agree to it, guess what? That's how we turn what appeared to be non-positive, quote-unquote, law, and we throw it out so it's never used against the American people again. Jury deliberation. The jury then retires to the jury room to deliberate its findings. This can take a few minutes to many weeks. After deliberation, the jury will announce its verdict. In a civil case, the jury also assesses damages. The judge assesses penalties in criminal cases. Entry of judgment. After the jury has returned its verdict, in most cases, the judge will enter judgment to the successful party based on the verdict. This is the official decision of the court. The court may, however, overturn the verdict if it finds bias or jury misconduct. This is called a judgment notwithstanding the verdict, or judgment novo or genovo. In a civil case, the judge may reduce the amount of monetary damages awarded by the jury if he finds the jury to have been biased, emotional, or inflamed. This is called remittur. 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 The trial court usually issues a written memorandum setting forth the reasons for the judgment. This memorandum, together with the trial transcript and evidence introduced at trial, constitutes the permanent record of the trial court proceeding. In the fall, the appeal. If you don't like how it all turned out, in a civil case, either party can appeal the trial court's decision once a final judgment is entered. Only the defendant can appeal in a criminal case. The appeal is made to the appropriate appellate court. A notice of appeal must be filed within a prescribed time after judgment is entered, usually within 60 or 90 days. The appealing party is called the appellant or petitioner. The responding party is called the appellee or respondent. The appellant is often required to post a bond, 1 1/2 times the judgment on appeal. Now, when you have the acquired knowledge that I have, you realize you have the power to write your own damn bond, because a judge sitting on a bench is really a banker sitting at a bank, because bench means bank, Black's Law 4th edition and 6th edition, and judge means banker, Black's Law 4th edition and Black's Law 6th edition. They are circular in nature, and they are administering a bankruptcy, ladies and gentlemen. So don't let them fool you. You have the power to create new money in the economy. You write your own damn bond, and they have to accept it pursuant to 40 Statute at Large, USC 411, Section 7E and 8A. Don't let them pull your chain. Let them know you know what the fuck's going on. All right? The parties may designate all or relevant portions of the trial record to be submitted to the appellate court for review. The appellant's attorney may file an opening brief with the court that sets forth legal research and other information to support his contentions on appeal. The appellee can file a responding brief answering the appellant's contentions. Appellate courts usually permit a brief oral argument at which each party's attorney is heard. An appellate court will reverse a lower court decision if it finds an error of law in the record. An error of law occurs if the jury was improperly instructed by the trial court judge, procedural evidence was admitted at trial when it should have been excluded, procedural evidence was obtained through an unconstitutional search and seizure, that's called fruit of the poisonous tree, and the like. An appellate court will not reserve a finding of fact unless such finding is supported by the evidence or is contradicted by the evidence. Alternative dispute resolution. The use of the court system to resolve business and other disputes can take years and cost thousands, if not millions of dollars in legal fees and expenses. In commercial litigation, the normal business operation of the parties are often disrupted. To avoid or lessen these problems, businesses are increasingly turning to methods of alternative dispute resolution, otherwise identified as ADR, and other aids to resolving disputes. The most common form of ADR is arbitration. Other forms of ADR are mediation, conciliation, mini trial, fact-finding, and judicial referee. Arbitration, a form of ADR in which the parties chose an impartial third party to hear and decide the dispute. In arbitration, the parties choose an impartial third party to hear and decide the dispute. This neutral party this neutral party is called the arbitrator. The arbitrators are usually selected from members of the American Bar Arbitration Association, the AAA, AAA, or another arbitration association. Labor union agreements, franchise agreements, leases, and other commercial contracts often contain arbitration clauses that require disputes arising out of the contract to be submitted to arbitration. If there is no arbitration clause, the parties can enter into a submission agreement whereby they agree to submit a dispute to arbitration after the dispute arises. Evidence and testimony are presented to the arbitrator at a hearing held for this purpose. Less formal evidentiary rules are usually applied in arbitration hearing than at a court. After the hearing, the arbitrator reaches a decision and enters an award. The parties often agree in advance to be bound by the arbitrator's decision and award. If the parties have not so agreed, the arbitrator's award can be appealed to court. The court gives great deference to the arbitrator's decision. Congress enacted the Federal Arbitration Act to promote the arbitration of disputes. About half of the states have adopted the Uniform Arbitration Act. This act promotes the arbitration of disputes at the state level. Many federal and state courts have instituted programs to refer legal disputes to arbitration or another form of alternative dispute resolution. Mediation and conciliation. In mediation, the parties choose a neutral third party to act as the mediator of the dispute. Unlike an arbitrator, a mediator does not make a decision or award. Instead, the mediator acts as a conveyor of information between the parties and assists them in trying to reach a settlement of the dispute. A mediator often meets separately with each of the parties. A settlement agreement is reached if the mediator is successful. If not, the case proceeds to trial. In a conciliation, the parties choose an interested third party, the conciliator, to act as the mediator. Mini trial. A mini trial is a session usually lasting a day or less in which the lawyers for each side present their case to representatives of each party who have authority to settle the dispute. In many cases, the parties hire a neutral person, ergo a retired judge, to preside over the mini trial. Following the presentation, the parties meet to try to negotiate a settlement. Fact-finding. Fact-finding is a process whereby the parties hire a neutral person to investigate the dispute. The fact-finder reports his findings to the adversaries and may recommend a basis for settlement. Judicial referee. If the parties agree, the court may appoint a judicial referee to conduct a private trial and render a judgment. The referee, who is often a retired judge, has most of the power of a trial judge, and his decision stands as a judgment of the court. The parties usually reserve their right to appeal. Thank you for joining me. I hope that helps you out and provides a little bit more clarity. When we come back, we'll be talking about the Constitution of the United States of America and be delving in deeper into that.